Citizens United. Somebody booed already? Somebody booed? Who booed Citizens United? Well, you're not alone. 2 years ago this month, the Supreme Court decided the Citizens United case, and it's probably the most important First Amendment case of the 21st century so far, and certainly is the most politically controversial case in recent memory. There's a lot of people who boo it and complain vociferously about how the court reached its decision, the merits of the decision, the consequences of the decision, and there's a lot of rhetoric flying around that is not really accurate. The decision is bad enough as is, and dangerous enough as is, without misrepresenting what it actually decided. For example, people will say that the court decided that corporations have the same rights to free speech that individual real human beings have. The court didn't actually say that, and certainly didn't hold that. People say that the court decided that super PACs, that now are dominating certainly the Republican primary, and it looks like the elections for this year, that super PACs could be used secretly by corporations. Well, the court did not utter a single word about super PACs in the Citizens United decision. I don't think there were any super PACs until Citizens United was decided and then digested by the lawyers who run political campaigns. People say that the court allowed corporations to secretly flood political campaigns. That's not true, because the court upheld the disclosure provisions of the law that was involved in the case. We'll come back to that. And people say that the court said money is speech. And the court didn't say that. And we'll put in context what the court actually did say when we reach there. The decision was 5-4 along the conservative-liberal split in the court. The Roberts Court in January 2010 looked like this, which is not quite the same as today, because Elena Kagan had not yet been appointed by President Obama to replace John Paul Stevens. And Kagan, in fact, argued the Citizens United case for the government, defending the campaign finance law and losing the case when she was Solicitor General of the United States. That's the lawyer who represents the government in Supreme Court proceedings. The court decided 5-4 that a provision of the McCain-Feingold Campaign Finance Reform Act was unconstitutional on its face as a violation of the First Amendment. The law that was struck down prohibited corporations and unions from doing an electioneering communication, basically meaning a television ad or a radio ad, supporting or opposing a candidate for office within 60 days of an election. 60 days before, they could take out an ad supporting or opposing a candidate, and the prohibition was just in that window of time before the election. The law applied to all corporations, including nonprofits and including issue-oriented nonprofits, like the Sierra Club, for example, or the ACLU. It did not apply to media corporations, whatever they are. Some you know what they are, like the New York Times Company. Others you may not be too sure. For example, NBC, isn't it? NBC is owned by General Electric. Well, is General Electric a media corporation? They make light bulbs, they make jet engines and all kinds of stuff. Are they a media corporation? Well, they own NBC. Nobody knows for sure. The values that collided in the Citizens United decision were the value of unrestricted political speech. Everybody's in favor of that on one side, and on the other, keeping corporations from dominating and contaminating elections by flooding them with money, corporate money. And the law prohibited corporations and unions from using their own funds out of their own treasury to buy television ads supporting or opposing candidates. Corporations have been prohibited from directly contributing to a candidate's campaign for a very long time, and that provision was not involved in the Citizens United case. That provision is still out there. The corporations can't directly contribute to a candidate's campaign, but they now, after Citizens United, they can independently of the campaign take out ads supporting or opposing political candidates. So the court came down heavily, the 5 conservative justice majority came down heavily on the free speech side, the First Amendment side, or the corporate side, depending on how you look at it. The reaction to the decision was strong. The liberal establishment was highly upset with the decision. The New York Times immediately published a fairly hysterical editorial opposing it and saying this is going to, to the extent that money doesn't already dominate all of our politics, this really opens the floodgates so that corporations are unleashed to pick their candidates, pick their issues, and buy them with money. There were calls for constitutional amendment. There still are, and they're serious calls. We'll consider those in a while. Locally, some of the reaction, even the movie theater got involved, marqueing that the Supreme Court's a disgrace. Corporations are not people. Impeach the Supreme Court 5. That is, the 5 who voted in favor of the First Amendment. People for the American Way, the liberal lobbying organization, said that the court, quote, staged a hostile takeover of American democracy on behalf of corporations. And then you may have seen this cartoon on the internet with the justices who voted in favor of the corporations festooned with corporate logos, all but the, quote, liberal dissenters. People complained about how the court reached its decision. It didn't start out to be such a blockbuster case. What happened was that Citizens United, which is a conservative, nonprofit, issue-oriented corporation, produced an hour and a half, 90-minute documentary during the 2008 presidential primary campaign when Hillary Clinton was running against Barack Obama in the Democratic primaries, and Citizens United produced this hatchet job on Hillary Clinton. It was basically critical of her character and her politics and everything about her. It was an hour and a half diatribe against Hillary Clinton, and the Citizens United was able to show it a few places, but leading up to the primary elections in various states, they wanted to put the film on video on demand, by subscription, but they were afraid that the law would prohibit it from doing so, and the law carried criminal sanctions. So rather than risk prosecution, what Citizens United did was sue the Federal Election Commission for a declaration that the law didn't apply to it, didn't apply to the film, didn't apply to video on demand, and therefore couldn't be enforced against Citizens United. Those were three separate arguments. They argued that the law should not apply to this 90-minute documentary. That's not like a television ad, which was the real target of the law. This is a movie, not a spot of the kind that Congress was targeting by the law. And then they argued that the law shouldn't apply to video on demand. That's a place where people affirmatively choose to watch the thing. The content doesn't assault you from your television set unsurprised. You have to go seek it out, and the law shouldn't apply to that kind of communication. And finally, the Citizens United argued that the law should not be interpreted to apply to it, which is a nonprofit, issue-oriented corporation, mostly funded by individuals, not by corporations. So the Citizens United brought this case arguing that the law didn't apply to it or its film. And in the district court, in the federal trial court, Citizens United even stipulated, that is, formally agreed in the court, that it was not challenging the law on its face. When a law is thrown out on its face, that means it can't be applied to anybody in any circumstances. It is completely invalid. And as a matter of tactics, Citizens United said, well, Judge, we're not challenging this law on its face, only as applied to us. Well, when the case reached the Supreme Court, it was argued once, early in the year 2009, and the court deliberated and didn't decide it that term, and instead, at the end of the term, the summer, set the case for re-argument, special day, not even during the regular term, special day in September before the next term opened, and requested that the parties brief, that is, argue, whether the law should be invalidated on its face, not just as applied, and whether two of the court's precedents dealing with campaign finance should be overruled. That's something that Citizens United had not even asked the court to do. There were two cases, basically, one and a half, one 30 years old, 20 years old, I guess, 1990. The Austin case, where the court had upheld a Michigan law that was virtually identical to the federal law that was involved in Citizens United. And then there was part of another precedent that the court called into question. So the parties did brief that, argue that on that special day in September, and then the court, 2 years ago in January, handed down this decision, which struck down the law on its face, decided that it wouldn't get involved in trying to decide whether the as-applied challenge of Citizens United should prevail, because the law was invalid on its face, and in the process overruled the Austin decision from 1990, the Michigan decision, and part of another decision. It was a breathtaking example of judicial activism. The court basically abandoned the principles of judicial restraint that Chief Justice Roberts had testified about in his confirmation hearings in 2005, when he had been appointed by President George W. Bush to be Chief Justice. He had to go to hearings before the United States Senate. And while he was there, he, in expressing his judicial philosophy, said that he was strongly in favor of unanimity in court decision-making. That is, to the maximum extent possible, decisions of the court ought to be unanimous on matters of great consequence, like, for example, Brown versus Board of Education was a unanimous decision of the Supreme Court. Well, Chief Justice Roberts said one way to achieve unanimity is to decide cases on the narrowest possible grounds. Don't paint with a broad brush, just proceed incrementally and decide cases narrowly rather than broadly. And then he extolled the virtues of the doctrine of stare decisis, the common law doctrine that the court considers itself bound by. That is, that you have to respect precedent, respect the earlier decisions on the same issue. And as a matter of judicial restraint, that's what you do. You don't just, when you got a new bunch of justices on the court, say, oh, all those other decisions before us were wrong, and now here's what we think the law is going to be. Rather, establish continuity and respect for the rule of law by respecting precedent. Well, where did all that go in Citizens United? Out the window. The court ignored all of those principles of judicial restraint in favor of deciding that this law was unconstitutional. The decision was written by Justice Kennedy for the 5-justice majority. I have to say that Justice Kennedy is, in my opinion, the strongest judge on the court on First Amendment issues. He has taken some very unpopular positions, and I applaud him for that. And I don't know whether he thought, in writing the opinion in Citizens United, that he was writing a triumphant First Amendment decision, or whether he, together with his conservative brethren on the court, was basically deciding in favor of the interests of business. But in any event, he had to say, in the course of writing the decision, he had to emphasize the breadth of the law that was involved. He noted that the law applied to every corporation, nonprofit and not accepting media corporations, that there are 5.8 million for-profit corporations in the country. Most of them are small. They're not Exxon and General Motors and Google and so on. Most of them are small. Many of them are mom-and-pop operations, sole shareholder corporations, a little store that happens to be incorporated. And of course the law applies to all labor unions, including advocacy organizations, and that led him to use the example of what would be felonies under the law as it stood. If the Sierra Club, a corporation, took out an ad opposing a candidate who wanted to mow down all the trees in national forests, that would be a crime under the law. A National Rifle Association book that supported a candidate who favored doing away with gun control, that would be a felony. And if the ACLU website supported a candidate who defended free speech, that would be a felony. I mean, that gives you an idea of the, you might say, absurd breadth of this law that they were dealing with. It certainly raises First Amendment concerns. And the restriction by the law on political speech is what Justice Kennedy repeatedly emphasized, pointing out that the First Amendment literally applies to speech, freedom of speech. It does not single out individual speakers as being protected. And the court said, Justice Kennedy for the court, that when you're dealing with political speech, which is at the core of the First Amendment, there can be nothing more political than the speech about candidates in an election. That speech does not lose its First Amendment protection, political speech, because the speaker happens to be a corporation rather than an individual. The identity of the speaker as a corporation does not deprive the speech, which is protected of constitutional protection. The he espouses in the course of the decision these wonderful First Amendment principles that have been culled from prior cases decided by the court. Speech is an essential mechanism of democracy, for it's the means to hold officials accountable to the people. The First Amendment has its fullest and most urgent application to speech uttered during a campaign for public office. More speech, not less, is the governing rule. That goes back to an opinion by Justice Louis Brandeis in 1927, where Brandeis's opinion laid out some of the theories for protecting free speech, and basically said if the government is concerned about subversive, misleading speech, the remedy for that is not suppression of what somebody wants to say, rather it's more speech. Allow everybody to have their say, and through that process, the truth will win out. And so the emphasis of the opinion is on protecting political speech, regardless of who the speaker is. We, the people, are entitled to hear all points of view, and the government should not be allowed to disfavor speech based on who is speaking. Justice Kennedy says this is premised on mistrust of government power. But this is great stuff. This is wonderful First Amendment reasoning. Unfortunately, all of these principles were put to the service of corporations rather than the dissidents, the minorities, the eccentrics, the disfavored people whose voice will not get heard without the assistance of the First Amendment. Corporations don't have any problem getting their voice heard.
I have a question on how Citizens United reacted to this.
On how what?
Citizens United reacted to this decision because they think the entire case didn't actually go against Citizens United, but the literal corporation had no money. So they got a reaction.
Citizens United crowed about it. I mean, check out their website. They thought it was the most wonderful event in American history that their voice could triumph in the situation. I don't know whether they still think that, but certainly that was their initial reaction. People say, the court said money is speech. The court did not use that phrase. What the court did do is quote from its 1976 decision, the first significant campaign finance decision of Buckley versus Valeo, V-A-L-E-O. And the quote was, a restriction on the amount of money a person can spend on political communication during a campaign necessarily reduces the quantity of expression by restricting the number of issues discussed, the depth of their exploration, and the size of the audience reached. And that seems to me self-evident, that in order to get your candidate elected, to get your candidate's message across, you have to spend money. How else can you do it? You've got to print brochures and leaflets, and you've got to print signs for people to hold up at rallies, and you've got to put up billboards, and you've got to buy radio and television time. Otherwise, you can't possibly compete in the modern election environment. So you can say money is speech if you want, and it's a derogatory way of putting it, but in fact, in order to speak in an election, you have to use money. Carl?
I understand how corporations making up politicians can mobilize their campaigns, but I come to my fair view that individuals, if I can't compete with a corporation, if I'm going to a politician here in favor of another politician, they're going to get their message spread faster. I can't run resources, so I think it's fair that corporations are individuals. But when they're like giants, we're strengthening the U.S.
Right. That was one of the rationales on which this law was premised, one of the rationales that was adopted in the Austin case in 1990. They called it the anti-distortion rationale. That is,